The day following the passage of the contentious UPDF Amendment bill yesterday and the political parties bill. Of course, there were two things that were happening there, and because of the contention around the return of civilians to the military courts, that was overshadowed, and we're going to ensure that we bring you up to speed with all that. We're expecting to speak to Honorable Ronald Balimwe, or the MP for Nakawa East and aspiring Lord Mayor, but that will be a little bit later. For now, though, let's begin with Timothy Chimonges. Timothy Chimonges is Executive Director at the Center for Policy Analysis. He's also one of the honchos that do write about the goings on, especially the official ones in Parliament and Parliament Watch. You're most welcome to Morning at NTV, Timothy.
Thank you so much, Chris. Good to be here. Looking forward to a very fruitful discussion.
Yes.
You highlighted earlier about the state of our roads, the state of our infrastructure in the country, and we are in a place where we need to put a bit of more effort. We lose at least 14 people every day on roads. The cost of road crashes and all those fatalities that we see amounts close to 5% of our GDP.
Of our GDP, yeah.
That's quite a bit, close to 7 trillion if amounted, and that's according to the WHO report, the most recent one. And some of those resources going into what we see in Mulago, you see quite a number of people being treated there, or there's quite a lot of resources that go into that direction.
That is right.
Money that ideally, if we had taken appropriate action, we wouldn't be spending or even incurring as a country. So it's true and very clear that there's a need for more attention, there's need for more proactiveness on both sides, both on the on government side, but also
citizens themselves and other institutions.
Yeah.
Thank you for that very good perspective, one that offers us the inspiration to ensure that we continue amplifying these issues. And your good offices, for example, are pretty much well positioned, and we are counting on you more than anything else to ensure that this comes through. Now, in light of the top story in the land, the contention about the return of civilians to the military courts and everything around it, one thing we must make very clear to our audience is that what passed yesterday was a law or a bill, because it's yet to be assented to, is a bill that has a lot more issues than just the return of civilians to the military courts. But we must be attentive to the tone within the country, what the bone of contention really is. Because at the end of the day, I was speaking in our point of reflection, why the aspects about welfare administration within the Uganda People's Defence Forces were not effectively captured in the UPDF book. The one that transformed aspects including command. The fact that it all overcomes as necessary is quite telling of the intentions, but let's get your views on how events yesterday went on and what you make of that.
So starting really is to say that it's very unfortunate as a country that we found ourselves here, where the question of legislation, the question of passing laws is in a way frustrating the overall governance of the country. And so, and I say that because when you look at Article 72, Article 79, Clause 2 of the Constitution, it gives Parliament the mandate to make laws for peace, order, good governance of the country, and equally development. And that mandate is envisaged that Parliament will put the interest of the country first in legislating. The passing of the UPDF Amendment Bill, amidst what you've highlighted, the good things that are listed in there, it goes without saying that when you hide your target in good things, so you you have the government presents the other good components of, you know, the welfare of the police and the other things, and then you reintroduce something that is quite contentious and put it in there in this specific amendment. It's just it's important for the rest of us, because a question of the trial of the citizens in military courts is a matter that we've just recently dealt with. And the Supreme Court has been very clear in terms of how we should proceed on this matter. And so when we are considering this, first of all, I think that it is very clear that we should be able to focus on major on the majors and minor on the minors. And so for me, I think that looking at yesterday's events, for me it is it's reaffirming that indeed there is a fundamental problem in how we are going about our business as a country, in how the institution of Parliament, which is charged with the mandate of ensuring that it offers guidance to the country and offers critical support that is necessary to the executive in that manner, has fundamentally been affected. But also, more importantly, looking at it from the constitutional perspective, that whereas the Constitution indeed gives and provides the framework in which many of these things should be done, we've chosen to do them otherwise. Maybe just as an example, the consideration of the UPDF Amendment Bill, the manner in which it was passed and the time period in which we had for it to be considered is something that raises eyebrows. The Parliament made a call on Thursday last week, inviting the public to present their views and to express their interest in interfacing with the committee at Parliament and present out their views. So the organization that I head, the Center for Policy Analysis, was one of the institutions that presented.
You had an opportunity too?
No. We didn't. We presented a letter requesting to appear before the committee.
And you weren't granted that?
Yes, nothing. None of that was. Although we also submitted the memorandum. A memorandum clearly highlighting our key issues that we had, that we thought that needed to be paid attention to. Our expectation was that as a part of the lawmaking process, Center for Policy Analysis, together with the other stakeholders, would have an opportunity to weigh in on this matter. Lo and behold, I think that opportunity is missed, having the bill having been passed. And what that speaks to is on the question of the consultativeness of the lawmaking process. That this law is aimed at, you know, contributing to the governance of this country.
That's right.
And that stakeholders have a role to play in how these laws come out, because, you know, they're affected. So how the bill was passed raised quite a bit of eyebrows on our side. But also, more importantly, I think that Parliament itself as an institution, while exercises the agency that the citizens have granted unto them, increasingly we've seen that has been abused, that has been undermined, but also the continuous bravado by Parliament and the institution in how it conducts its business is one thing that comes out very, very, very clear, and it's quite unfortunate.
Okay. That's an interesting one. Just for clarity purposes, what would be the ideal time frame to give such a law, especially with regard to consultation of the various stakeholders? Earlier in the program, I was asking and wondering whether the Equal Opportunities Commission was given an opportunity, or even if, or did they even interface as in seek to give their views? Ideally, how much time would be necessary for a comprehensive consultative process before the bill is brought before the processes that we saw over the last week that culminated into the passage yesterday?
So as a bare minimum, and when we refer to the rules of procedures really in how the law making process looks like, the rules of procedure provide that committees, upon receiving the bills, have up to 45 days.
45 days.
45 days to consider the bill. And that would also include the process of listening to stakeholders, but also coming up with the report that will inform the debate on the floor of Parliament. But for the 45 days have exceptional circumstances where the committee, upon consideration of the nature of the matter before them, they can come back on the floor of Parliament and request for more time. But the standard time is 45 days.
45 days.
Yes, but each bill must be looked at with its own merits and with its own gravity of the issues that are being dealt with. For this specific one, I thought that even there needed to be an extensive deliberation on this matter. There is no rush. Why are we rushing? We still have some time. But looking at the rush that Parliament actually seemed to have been in, where we've also seen that a section of the committee members who were considering this bill have continued to raise concern that while they were coming up with the report, and the leadership of the committee went to, I think, to the State House for caucus, and they had reached halfway of the development of the report. They were shocked to see that there is a final report, and that led by Honorable Gilbert Olanya, the Kilak Member of Parliament, raising that we don't know where the bigger chunk of the report came from. Yeah. So there's a fundamental problem in terms of how we are looking at the legal framework of our country, but also, you know, looking at how the process is handled, looking at the manner in which this whole process is actually being viewed. It tells you that it sends a message that there is a bigger interest to these bills beyond what we are seeing. Okay. Because for what purpose would be for Parliament really to quickly handle a bill which has a very serious ramification in terms of its implication, but also we've just had the Supreme Court giving guidance, which I still think that Parliament used and went against the Article 92 of the Constitution, where Parliament is barred from making laws in a retrospective manner. And I think we've seen the opposition have promised to go back to court, and we shall be seeing how the courts will be guiding on this matter. But of course, that is after some time. We don't expect the courts to quickly handle this matter. So that's yeah.
I'll be engaging you on the aspect of making laws in a retrospective manner, and whether this one would actually go backwards to cater for some of the cases that we know might be the target. It also addresses the issue of why there was a rush into this whole thing. But allow me stay on the context of consultation. Under what circumstances can the consultation process, if at all it's given the time or that is deserved, can it alter the trajectory of legislation? For example, stakeholders are called in for consultation and there is overwhelming disagreement with the content of a particular bill. Can that alter the trajectory of that bill? Or we see the consultation process and the announcement or invitation to some stakeholders as merely a process that is done for accountability purposes? Can that really alter the trajectory of legislation?
The nature of our consultations in Uganda here are quite interesting. We have stakeholders' views as purely persuasive in nature. It only means that it's at the discretion of the committee to either take in or to discard or to look into the submissions of the stakeholders. So it's purely at their discretion. There is no requirement that they must take or they must include they must take any of the recommendations by the stakeholders. We in 2022, I think, 2022, we had a very contentious bill of the Computer Misuse Amendment Bill. And there was an overwhelming disagreement of the proposals that had been proposed by government then. And looking also further, including the Ministry of ICT then, who had appeared before the committee, and they entirely disagreed with the position that the bill was proposing. So you at that point in time, by the time the committee was ending the consideration of the stakeholder engagement, there was overwhelming disagreement, including the line ministry of the amendment of that Computer Misuse Act. And that was a bill that had been moved by Honorable Nsereko. The committee went ahead, and in total disagreement with the stakeholders' views, they passed the bill. So it's to say that increasingly we are seeing that the question of consultations are simply a mechanism to legalize or to provide justification, legitimize the whole component. And I think it's the same thing really with the UPDF Amendment bill. Even if we had been given an opportunity to engage the committee, I actually think that the position had already been made a long time ago. Looking at the question, because it's true that there's been a lot of investment, both resources, where we've seen a section of members of parliament, if not all, have received, the famous 100 million shillings. For looking at the timing of that money, you are convinced to say that indeed the money was aimed at facilitating or encouraging the section of members to vote in favor of this. There's a lot of time that had been invested in this specific bill, but also I think that the political strategies that have been put in place are very clear in terms of the upcoming general elections.
Thank you very much. That is some clarity on this particular issue. Now, with regard to the Supreme Court ruling, the one that triggered this particular bill to come into play, I want to ask you the question, where does this leave the judiciary? Because you like it or not, the statement is clear. There has been the red line drawn in the sand. There is where you can go. There are places or areas that you should not go beyond. Yet, in the dispensation of justice, the ability of the judiciary to be the last arbiter must be maintained. Right now, I can clearly state that even when the Supreme Court will face another contentious trial before it, or a case before it, we cannot trust that what they will say will be the final thing and maybe the safeguard for justice in this country. Where does this leave the judiciary right now? What kind of conversations are going on, especially for those that are not cadre officers? So I think this really puts and places the judiciary in a very tricky place. But nonetheless, I think that it's also an opportunity to test the positioning and the status of our judiciary in terms of protecting and upholding the rule of law. I'm more inclined to looking at this towards the direction of damage control, really. I think that irrespective of how the judiciary in the coming months or in the coming years, whichever way they decide to guide the country in light of the matter before them as it will be presented, the challenge is the damage that has already occurred. So in the petition by Michael Kawaziguruka, by the time the bill had moved right from the High Court to the Supreme Court, when you look at the amount of damage that had already happened, when you see the number of citizens that had been tried, the citizens that had been put in custody. I think we can even call it the incidents of miscarriage of justice.
Yes. So the amount of miscarriage of justice that would have been conducted or would have happened is so much so that even when the court decides in favor of the people in terms of upholding the rule of law, there is no way that kind of damage can be compensated or can be undone. And I think that looking at the Supreme Court's position recently, I noticed that the courts were extremely careful in providing mechanisms in which individuals who had been affected right from the time this matter was brought to court.
That's right.
For either compensation or a mechanism of ensuring that the damages that had happened are paid off. So the Supreme Court was very, very careful in that direction. And of course, I also noticed that there are quite a number of orders that were issued were a bit vague. Like, for example, you see the order of having, you know, cases transferred from civilian courts from the military courts to the civilian courts, quite also vague. I mean, because up to today, except for a few cases like that of Aaron Kiza, most of the files are still with the military courts, despite the position that the Supreme Court has had. So there are a bit of vaguenesses that we've continued to see. But also, broadly speaking, I think that the question of the military rule vis-a-vis the civilian rule in the country is at a very critical role, despite the Constitution clearly highlighting that the military rule or the military rule will be subordinate to the civilian.
Doesn't look like it's happening anytime soon.
Yeah, so it's a place that we're in a struggle where the country is testing this specific provision, but those within that framework, within the military, seem not to be willing to give away any of this power, and so they're going to fight extremely hard to still retain it.
Interesting there. I'll be going into the question of the boycott by the opposition, especially given the fact that hours before or the previous day, there was what appeared to be unanimous agreement on the part of the opposition for them to come, be part of the process, cement their place in history, debate any aspect of the law that they thought was worth debating or clarifying, especially for the national audience. But then again, the drama ensued right before the entire debate would get underway. The walkout was conducted. One of the MPs questioned exactly the thinking behind that kind of maneuver, though some of them say it was intended to be a political masterstroke by the opposition. I don't know exactly how. You will give us your views on that. But let's attempt to explain to the audience out there. When it comes to trial of civilians in the military courts, as the law requires now, there are 4 prongs. One is where the person voluntarily accompanies any unit of the defense forces which is in active service in any one place. What's the meaning of that?
So I think that, you know, that as of the now amendment that has been passed. But just maybe before explaining that, I think that it's also important to say that the amendment of the UPDF Act creates the exceptional circumstances without a clear definition of what these exceptional circumstances look like. So beyond this that you are lighting the 4, there are exceptional circumstances that clause 30 of this very bill that attempted to provide, but it creates it vaguely and provides room for interpretation for whom it may concern to interpret exceptional circumstances. And that's why our biggest concern and still is that while the Supreme Court indeed said that civilians should be tried in the civilian courts, but may in extremely exceptional circumstances, in extraordinary situations, may be tried in the military courts. What the government did, they went to ensure that they copied that specific provision as of in the ruling and brought it in the law. And so as it is today, it's even in a worse, we are in a worse place today more than when we were then. So for most of this, again, we must appreciate that any legal framework, including the rulings of the court that are vague in nature, are simply in favor of those who enforce it. That is because right. Then it allows them the leeway to interpret it in whichever way. Yeah. We've had the confusion, for example, of the Supreme Court, where you see government interpreting in its own way. You have the rest of us this side trying to make a case that the court actually guided this way. So amidst that confusion and amidst the trying to find the middle ground and the clear understanding of what the court could or may have meant, there's a lot that is happening. So it only goes in favor of those who would be enforcing this specific law. And for this specific provision, I think it would go to the extent of any individuals who find themselves either in possession or in place within the items that are a preserve of the military.
Of course, what I gather from a layman's point of view, when I see the words voluntarily accompanies any unit of the defense forces which is in active service, many of us have brothers and sisters who are in the military, and there is a possibility that at any one point in time you might accompany your brother. You could be seeking something as simple as a little bit of help. Every Ugandan does that. And then this gentleman says, why don't you come along? Now, in the process of travel, there is a lapse of judgment on the part of the soldier you are accompanying. It wasn't meditated between the two of you, but because of the lapse in judgment, that soldier commits a crime. The law says you're complicit. Absolutely, you are an accomplice according to the definition that is there. So it's vague, and sometimes, you know, and the unfortunate bit is that it could actually proceed to even spouses if the interpretation is put in a manner that slightly goes against this. And that the spirit of this particular clause in this case means if your spouse, and let's use the case of the principle of the National Unity Platform, for example, Robert Chagulanyi, is found on the other side of the law, it effectively brings the spouse into the picture. Correct. As an accomplice. Interesting. That is the second pro, where the person aids or abates a person subject to military law in the commission of or conspires with a person subject to military law in committing murder, aggravated robbery. You might not know that this person is That's correct. All right. I think at the end of the day, we need 2 hours with the Uganda People's Defense Forces spokesperson so that some other aspects of these particular contentious clauses are addressed. I'm also interested in what the unlawful possession of arms. For example, if you're found in unlawful possession of an arm and then you use it, what happens to those who have guns lawfully and then they commit a crime? Do they go to the military court or they go to the civilian court? So that's where the problem is. You know, there's quite a lot of vagueness in how these provisions are actually designed, and we've missed an opportunity. I mean, much as you may want to invite the spokesperson, the most that you can do really is to explain and to make a case for what they think is right. But we've lost an opportunity that Parliament should have provided us to engage and offer guidance and offer our views in light of this. Because at the end of the day, the laws as presented, they are for the good of this country. And we must collectively see how we weigh in
and push and have a very clear law. So unfortunately, we've missed this opportunity. The most we can have is a situation where really explanations in favor of what is happening. Yeah.
Okay. Let me go into the question of the boycott, and it's something that is very interesting. We haven't had an opportunity to understand the deeper underlying question that condition the change of mind. But again, political drama is nothing that we are not accustomed to in the country. Do these boycotts really mean anything?
So in the grand scheme of the strategies that different parties, especially the opposition, who are of course at the groups of people that largely utilize this, I think it's depending on the circumstances. Boycotts are very effective, but also they are one of the options that the opposition have. Sometimes not only just to look into the matter that is at hand before Parliament, but also sometimes as a strategy to advance discussions on the specific matter, but also to express and to physically, show the displeasure on what is happening. Of course, it would have a bigger impact if you had a bigger number of opposition members of Parliament walking out.
That is right.
That it would have a very strong message and maybe a stronger impact. But as of the situation today, business can still continue, and whether you have the opposition members or not. But in the grand scheme of things, I think that it's one of those strategies that the opposition have to communicate, but also to find mechanisms of ensuring that the conversations can still go on. Because at the end of the day, most of these bills, whether with the opposition or not, they will pass. They will pass, yeah. And so what then, or what strategy as the opposition do you put in place to ensure that you can show your displeasure in the manner in how business is going? And this is not just for the bills. It includes how sometimes the presiding officer may be conducting business, or may be offering leadership in Parliament. But I also think that depending on the circumstance, I think like yesterday, I know members of Parliament have said we couldn't participate in legitimizing the whole process. But I think that there are times when the country requires a proper and a decisive weighing in on this matter, so that you're able to thrust out the real issues. Even when the bill will pass, you have an opportunity to, like I saw Honorable Dur yesterday. He did a very good job, and I think he deserves
staying and being able to articulate his concerns.
He did a fair job in trying to provide the minority side of the of their perspectives. Okay,
thank you very much. In the picture here that is shared by the Daily Monitor, as taken by Ibrahim Kavuma, I see the MP for Nakawa here, Ronald Balimwe. He'll be joining us very shortly, and maybe he's going to take us into a deep dive in exactly what happened, especially that change of mind on the part of the leader of opposition. Stay with us, we'll be right back. I'm glad you're still with us. If you are just joining us, you're so welcome on board. We are underway with our Kickstarter, and we are talking about the contentious passage of the Uganda People's Defence Forces Amendment Bill yesterday, as well as the Political Parties Amendment Bill that also was passed. We shall be talking about that in the latter stages of the program, but allow me for now welcome on board the MP for Nakawa East, Honorable Ronald Balimwe, who is joining us right now. Before we went into the break, I was looking at the Daily Monitor page 4 that has a picture that has Balimwe here and colleagues storming out of Parliament on account of a change of strategy, given the fact that just hours before the evening of Monday, I must be very specific, the leader of opposition, Joe Senyonyi, had instructed all MPs on the opposition aisle to appear and be part of this historic legislation in order to be captured on, as he said, the right side of history. I wonder what happened between the evening and the morning for people to be comfortable not to be on the right side of history. Honorable Ronald Balimwe,
so,
what happened between the time Joel Senyonyi addressed the media and the boycott yesterday?
good morning, viewers. Well, coming to your question, the order paper was made and distributed on Sunday. And the order paper is supposed to be made when actually the bill is done, completely processed.
Okay.
So that alone was an error. You cannot make an order paper when actually the bill is not yet completed, processed. But that was what was done. 2, at night there was a meeting by the chief whip of government. And in the meeting, he told those that were present that the bill is going to be presented as government brought it out. And therefore, it had not been processed. Before, when the bill was tabled the first time by government, Joel Senyonyi requested for ample time for us to process this bill because it was a serious bill. And the speaker asserted that we have within 45 days to process the bill. And we hoped that there was going to be consultations. Unfortunately, there were no consultations.
None at all?
No, there wasn't, I should say, because people were not given time. And such a bill of that nature that has great impact on the opposition, on the people of Uganda, must be given ample time. There's no reason for rushing. We have 45 days within which we could process that bill. There are very many people, key stakeholders that are going to come out and join us on our way to courts of law. Secondly, we thought it wise not to be part of something that was illegal, because the action of Parliament was constituting contempt of court. You are aware that in January, the Supreme Court ruled that civilians should not be tried in military courts. And by Parliament going ahead to do something that the court had ruled over was contempt of court. So for us being in the Parliament would be legitimizing an illegality. I don't know what my colleague says on that. But also, it is important that we had given them time. Maybe we thought that by the law coming out and telling the speaker that actually we are here. But it is important to note that there was no due process, and therefore suspend this bill, because we have a number of days in which we have to process the bill. And that is the reason that we actually went out.
In other words, you're saying after the leader of opposition addressed the media on the evening or afternoon of Monday, you expected some form of communication from the speaker.
Exactly.
And
that's the reason.
It didn't come through.
That's the reason that the law preempted the speaker several times. Because Parliament is the only space that we have to air out the voices of our people, and therefore we could not fail to attend.
So by saying and directing MPs to come and attend, you were putting pressure on the Speaker that never worked or achieved the purpose.
We didn't achieve that. So and what we had to do was to go out, and I think we are going to go to courts of law. That's the way to go. That's
an interesting one there. They had all the facts before the press conference, including the fact that there hadn't been consultation, and that the bill was appearing as it was in the report, and that holding the press conference was intended to put the Speaker under pressure. Do you believe that? Not the press conference. You know, we went directing that we went to Parliament, and the law came out, and they requested the Speaker to kind of suspend the bill because there were no consultations. There was no due process. And therefore you cannot proceed with a bill that was not processed. All right. You can't. Timothy, do you believe the Honourable?
No, you know, listening to Honourable Balimwe, you are inclined to imagine that they've just met and they have just got to know the Speaker in the recent past. These are fresh people. They just met the Speaker and specifically the Right Honourable Speaker Anita Among. They've dealt with the person of the Speaker and the leadership, and they know who she is. And they also are very much aware of the situations and the dynamics that go into passing of laws, especially that those that government have interest extremely, have high interest on the same. And so I also know that prior to when they were caucusing on Monday, there had been overwhelming displeasure, or a section of the opposition members actually saying that the opposition should boycott, not just going and moving out, but they should entirely not go into Parliament. And thus the strategy to go and move out prematurely was one of those that was settled on. Also the argument that the opposition, if it's true that they were going to convince the Speaker to call back the bill for further consultation, or try to convince the Speaker that indeed this bill has not had sufficient consultation and there is need for us to go back. I think that argument is on a scale of on the dynamics of what happens in Parliament does not pass the threshold. Because you see, Honourable, you've been in this and you know the level of interest and the level of amount of both time, resources that have been invested in this. So it will be not very accurate to say that you hoped. You hoped. And you were very convinced that indeed you would make a very strong case for this bill to be. Also further, in just what you said, Honourable, that... no, but Timothy, on that, there are quite a number of bills that have been passed by Parliament, where government has quite a lot of interest. For instance, the coffee bill. But it was processed well, because I know they have the numbers. So there is no reason why you give such a bill limited time. There wasn't any reason. You have the numbers, you have the money, you have even already given out the money, and you have all it takes. What we need is consultations. That's what we needed. You see, period. The issue is not on the time. It's agreeable that the time for the consultations was lacking. What we are looking at is on the conduct. It wasn't exhausted. No, actually there was nothing, because you see, exhausted means is that there were attempts to do consultations. There were no consultations, so there's nothing to exhaust. What we are looking at is on the conduct of the opposition first, and that's the question that you've put. That is right. On whether indeed the approach that they chose to take, or this was actually a premeditated, or did it actually deliver, or did it serve in the interest of the people? And what you're saying, for me at least, my position is that this was a premeditated position. And Honourable has actually said that on Saturday, actually I think it was on Saturday, that the order paper was out. The order paper was out. Saturday, not Saturday, not Sunday, as early as Saturday. Yes, but the bill was signed on Tuesday, yesterday morning. So it was not actually completed by the time the order paper was released. You can see. Interesting developments there. Now, I won't take you into the detail of some of the controversial clauses or the contentious. Somebody advised us not to use the word controversial.
but we shall stick to contentious. At the end of the
But you can as well use that because it is...
at the end of the day, it's wordplay, just like you're doing. Now, with regard to the grounds upon which you're going to court, one is the fact that the process was rushed without adequate public consultation. The very first one cited by the LOP is the fact that the UPDF law defies a Supreme Court ruling that stopped the trial of civilians in military courts. I want you to elaborate on your thinking here. We have a ruling of the Supreme Court in which the bench advised the executive, and this, I think I'm not very wrong, on how to rectify some of the aspects that it was uncomfortable with, especially in having civilians who have conducted themselves in a military manner tried in civilian courts. They were advised by the Supreme Court in that particular ruling. How can that be again the ground for a lawsuit? How do you intend to reason this?
No, it is clear. The court ruled that civilians shouldn't be tried in military courts.
But advised,
exceptional.
yes, in exceptional circumstances. And this has been brought out clearly because it caused issues yesterday. These guys are unable to explain elaborately what these exceptional circumstances, as advised by the Supreme Court, are. What's going to be your ground?
That is the reason that we needed ample time to process the bill and all those come out. But to us, according to the way the bill was brought, it did not address the issues of the Supreme Court. And I do believe that the action of Parliament alone constitutes contempt of court. And that alone is one of the reasons that we are going to courts of law.
In a way, you're going to sue yourself.
Secondly,
Parliament, because you're an MP.
Secondly, it is
first
clear.
Answer that question. Do you realize you're going to sue yourself as an MP?
I was not party to the actions.
Then it changes from suing Parliament to specifically either the Speaker.
We actually sue the Attorney General.
The Attorney General.
Yes.
And Parliament. Parliament also can be sued.
We sue the Attorney General.
Are you ready for this?
It is, we are ready for the battle. I'm not a lawyer, but we are ready for the battle.
Okay.
And not only as members of Parliament in the opposition, because these are affects, including him.
That is right.
I will give you a typical example where basically this law, if implemented, would be one of the worst laws. You remember during the by-election of Alua municipality, where the convoy of the president was alleged to have been shot. Stoned.
Yeah.
And the army went and cut off Bobi Wine's room, my president's room, hotel room, planted firearms and ammunition, and they alleged that these were a position for Bobi Wine, all of Bobi Wine. And they took him to the military courts. Where did that case end? So such scenarios can happen, where actually the army plants firearms and alleges that you own this, and you're taken in, and yet you actually have nothing to do with those firearms. So we want to basically stop that. And it abuses the constitution, the supremacy of the constitution of Uganda. So this law is not good at all, and therefore we should all, including Timothy, come and fight this vice.
True.
Absolutely.
Okay. We are first running out of time, and I had intended this. My brother,
good laws have good qualities. A law must be fair. A law must be in public interest. It must be consultative. But all these were not done. It must respect the supremacy of the Constitution of Uganda. So by all standards, this law does not qualify because there wasn't consultations, there wasn't, it is not fair at all. It has been brought in bad faith to fight the opposition and oppress the opposition. So we cannot accept such a law.
Great. Like I said, time is not our best ally right now. I would love us to also touch on the other law that saw the National Consultative Forum more like be taken out of the picture with regard to aspects including government funding for political parties. You also boycotted that one.
Yeah.
Ideally.
We did.
Why?
Because of lack of time for consultation. You know, these laws are brought in bad faith. The speed at which they were processed has never been there in Parliament. And they are there to oppress and suppress the opposition. This forum was created in 2010?
iPod.
2010.
Mm-hmm. Thereabouts. After.
Do you know any of its achievements? If government has failed to consult the people on a small matter or on a big matter, on this law, will it be able to consult the opposition parties, to mediate with the opposition parties? So we don't want to legitimize. And secondly, it is also important to note that parties are independent. And in the democracy, we have the Constitution that clearly gives the principles of democracy. One of them is the independency. We have the right to associate. We have the right of freedom to speech. And therefore, we cannot be forced to associate. That's out of order. You can't force me to associate because you want to lock me because of your finances. No, that's out of order. And this has been brought at such a time because they know we are in campaigns. They don't want us to have money to be able to do our campaigns in a manner that is acceptable. But believe me, we shall find ways, we shall devise ways of beating the virus.
Interesting there. We are running out of time. Timothy, this particular law that was also boycotted by the opposition and seeks to address aspects of funding and how parties can associate or not associate. This is widely seen as targeting the National Unity Platform that stayed away from the iPod dispensation right from when the party was formed. Of course, iPod was there far earlier than NOP was formed, having started way out in 2009, I think. That is the
2009?
2009 is when iPod was introduced. What is your take on this? And please wrap it up for us because we have run out of time.
No, I agree entirely with what Honorable Balimwe says. The spirit of the laws that we passed yesterday have and fall short of the standards in which the Constitution provides them. Make laws for the peace, order, development, and good governance of the country. It extremely falls short of that. I think that legislating to target the opposition the opposition political parties or mechanisms in which to push them towards getting in a specific direction does not serve the country. I know for a fact, looking at the dynamics today, definitely if the law is assented to, the NUP, if they successfully come back in the next parliament with the significant number of members of parliament, and the resources that that are located towards that direction are quite significant, and they will have very limited option other than joining. But the bigger question is, because the iPod framework is premised on the voluntary participation, voluntary membership, which has been greatly affected. Do we also have to go ahead and legislate on how, if NUP gets into iPod, how they will conduct themselves? They could choose to abscond, they could choose to frustrate the process, and which goes ahead, to frustrate the whole broader framework and purpose of this law. And so for me, in conclusion, I think that we have a fundamental problem in the institution of Parliament, in them serving, in them critically upholding the agency that the people have given unto them, but also protecting the rule of law as the Constitution has assigned to them. We have a fundamental problem in that area. Okay,
I would be remiss if I do not acknowledge the fact that the Honourable MP for Nakawa East is choosing to disengage and maybe change gears on how to go forward within the political landscape as Lord Mayor. Have you completely given up on your ability as a member of Parliament to effect change?
I am leaving Parliament for reasons. One, we are 529. It is very hard for you to catch the eye of the Speaker at certain times, that you become irrelevant in Parliament. I've been a mayor before, and I was one of the best serving mayors during that time, that I wish to go back to local governance, because I have the past experience in local governance. I have served from youth, LC1, LC2, LC3, LC5 as councillor, and now mayor, and now member of Parliament. So it's important that I go back on what I can do best. Local governance.
Thank you very much.
I've been an engineer, and the challenges of the city basically require an engineer, an expert in engineering, because majority of the challenges are engineering related. Therefore, I'm coming back to serve my people in that line.
All right, Honourable Ronald Balimwe, MP for Nakawa East, many thanks for making time. It's unfortunate you came in a little bit late, but you've been able to rectify some of our questions, or rather answer to, not necessarily rectify. And many thanks to you, to Timothy Chamonges, ED at the Centre for Policy Analysis, for what's no doubt very good perspective and has helped embolden our understanding of these very contentious bills. What we are sure about is that there is going to be assent to. No question about it. Do not think the president will bring these bills back for any other debate. That's it. Let me now go to my colleague, Stephen Mbide, who is on ground, and he's able to bring us some of those issues that are concerning the people. Good morning, Stephen.